Hello everyone, my name is Alison Goldthorpe and I'm a partner in the financial restructuring and insolvency team at Norton Fulbright in London. Welcome to this video, which is part of the financial restructuring and insolvency team's video series. I'm delighted to be joined today by colleagues from our New York office and our Montreal office.
Hello, this is Howard Belzer from the New York office.
Hi, this is Guillaume Michaud from the Montreal office.
Thank you, Howard and Guillaume. Today, we are going to be comparing the processes in the UK, Canada and the US for restructuring and rescuing businesses. We're going to start in the US, so I'm going to hand over to Howard, who will explain to you what key processes there are in the US and the features of those processes. Over to you, Howard.
Thanks very much, Alison. Hello, everybody. I'm going to be discussing aspects of US insolvency law that are most relevant to cross-border restructurings. Those primarily come up under Chapter 11, the General Reorganization Statute in the US, but they can also arise under Chapter 15, which involves a more limited proceeding in support of a foreign insolvency. The first aspect of Chapter 11 that is relevant to a cross-border restructuring is that it is very much a court-led proceeding as opposed to merely court-blessed. There are usually multiple hearings with various committees, each of whom has a financial advisor and a lawyer paid for by the estate. So there is much litigation in Chapter 11. This is true even in a pre-negotiated proceeding, so long as there are still some dissident groups or interests. It is not true in a real pre-pack, but those are relatively infrequent. The next aspect of Chapter 11 that I would focus on is the moratorium, or the automatic stay, which in the US is imposed automatically by statute, as the name would indicate, and applies, at least from a US law perspective, globally to all interests of the company all around the world. In a Chapter 15, I would note that the stay only applies to US assets of the foreign insolvent company. In Chapter 11, one of the primary characteristics of a plan is that it can be crammed down, both on dissident classes of creditors and on dissident creditors within a particular class. There are various legal hoops to jump through to enforce a cram down. You may have heard of the absolute priority rule, the fair and equitable rule, the best interests of creditors tests. In other words, there are many issues that dissidents can raise in the context of a cram down. So it's not always that easy to achieve in practice, but it is a very significant weapon to have, even theoretically, in the quiver of a cross-national debtor. Two other aspects to briefly focus on before I turn it over to my fellow panelists. One is the availability of DIP financing. DIP financing is post-petition financing to the bankrupt entity after it files, as opposed to pre-petition financing, which was already in place. And DIP financing can be incurred on a priming basis, meaning that the DIP lender gets a lien on assets of the estate in preference to the liens that already existed for the pre-petition lenders. So that is not always the case in other systems around the world, and can be a very powerful reason to include a US Chapter 11 proceeding in the context of a cross-border restructuring. The final issue I'd like to briefly touch on are so-called 363 sales. 363 is a provision of the Bankruptcy Code that allows a sale of the company's assets. So effectively, this enables an M&A process to be incurred in connection with a Chapter 11 proceeding. Again, a very powerful tool for parties to consider in a cross-border restructuring. Alison?
Thanks very much, Howard. So key points I've got from you on that are the features of the moratorium, court-led, cram-down, importantly, DIP finance, and Section 363. Guillaume, can I hand over to you, and can you let me know whether or not you have those kind of features in the Canadian system?
Thank you, Alison. Thank you, Howard. We do have very similar features in the Canadian system. In fact, the Canadian system is very much similar to the US one. We have some important distinctions or differences. They are not identical. If I take the few features that Howard mentioned, for instance, the DIP financing, it works the same way. In Canada also, it's a court-led process. I would say that the court will supervise the process. It is the practitioners will lead the court where they want to go, but it's not simply a role of blessing a transaction, or the court is supervising the whole process. So it's very similar in the US in that way. Among the distinctions that we may have, we do not have the cram-down features that Howard was mentioning. But those are the minor aspects, minor differences. Otherwise, it's very much similar. We also have what I call the three phases of a restructuring process that you will also find in the US. The first phase is a protection. So we do have estate proceedings. We have also the second phase where essentially you implement the restructuring tools, all kinds of features that allows you to fix whatever led to the insolvency of the company. And then the last phase is essentially to implement the fix, to implement the transaction that will remedy to the insolvency and allow the company to emerge, whether by way of arrangement or sale of assets, similar as well to a 363 sale in the US, or a distress M&A transaction. In fact, what is important to understand about the CCAA process, which is the name in Canada, is its flexibility. I often say that it's whatever, for a practitioner, it's whatever you want it to be, but in a sophisticated manner, in an organized way as well. And that's because the way it evolves throughout the years. CCAA is a legislation that is almost 100 years old. It was enacted in the 30s during the time of the Great Depression, and it was very controversial at first. It was a secured creditor-led legislation, and it was not used for many decades for that reason. It was too controversial. But then when the recessions of the 80s and the 90s hit, this legislation was essentially repurposed by the practitioners, reused, and the courts went along with it in order to allow restructurings of large corporations. The legislation at that time was skeletal in nature, so the practitioners, the insolvency practitioners, had to fill the blanks. The court allowed them to do it as well, because the overall purpose of the legislation was clear. It was to fix an insolvency situation in a manner that is most beneficial to most stakeholders. Throughout the years, it was then codified a little bit more to harmonize it as well to some features that were done in other jurisdictions, importantly in the US as well, considering the level to which the economies of Canada and US are integrated in our legal systems as well. But it never lost its flexibility and the possibility for the practitioners to be creative and find solutions. We also use a lot the Chapter 15 or the Canadian equivalent in order to implement cross-border insolvencies. This allows us as practitioners to pick the best features either in Canada or in the US for a given restructuring and to implement them. So that's something that is important in our practice more and more with years. There's some advantage that we can find south of the border, sometimes north of the border, and we try to organize our restructuring in a manner accordingly. And finally, the only thing I would mention, this flexibility has allowed the Canadian system to distinguish itself from other systems a little bit across the world by allowing us to really implement creative solution. And because of that, distress M&A has taken a very important role in the Canadian system in the last decade or so. We now have ways for companies to emerge from an insolvency situation that are unique, for instance, that allow us to vest out or to expunge from a company the undesired assets or liabilities in order to transfer that company through a share transaction to a buyer, a purchaser, and that's something that is unique and that is more and more used in Canada.
Great, that's really interesting, Guillaume. Thanks very much. And interesting that your procedure, your main procedure, is over 100 years old. And here in the UK, we're excited about our new procedure. Came into force in 2020 in the Corporate Insolvency and Governance Act, and it has a number of the features that both of you have mentioned. And so, perhaps by way of comparison of the processes, I'll just tell you a little bit about that. It was introduced into our Companies Act, so it's not an insolvency procedure, and it's a compromise or arrangement between a company and its creditors and shareholders if it wishes to compromise with them as well. And it's called a restructuring plan. The great thing about it is it does have cross-class cram-down, and we haven't had that feature in our arrangements before, and it will allow dissenting classes to be crammed down by sanction of the court on certain conditions. So the company can make the proposal to the creditors and the shareholders too if it wants to, and it then holds meetings of creditors, and at those meetings 75% in value of the creditors need to agree to the proposal for the meeting vote to be carried. Provided you have one class that agrees with the proposal, you can go back to court and then ask the court to sanction even if the other classes are dissenting. So this is a groundbreaking feature for us in the UK and something we haven't had before. We've had about 10 cases so far and counting, and it's really a monumental change for us in terms of flexibility of a process for really forcing creditors to be realistic about their position and being forced to agree, provided that they're not in a worse position than the relevant alternative. Contrast that with our previous procedures of administration and company voluntary arrangement, which we've had for many years, not as long as your CCAA, but since 1986. In administration was our procedure where we would try to rescue the company, and if not, look to sell it as a going concern. In that process, the directors are not in control, contrast with the restructuring plan where the directors remain in control. In an administration, an insolvency practitioner will take control of the business, look to rescue it, and if he can't, or he or she can't do that, they will then look to sell the business as a going concern. So that's very much not a debtor in possession procedure. It's one where control goes from the directors to an insolvency practitioner. An insolvency practitioner is usually an accountant in the UK who's taken some specially qualified exams which allow them to control the estate. They are appointed by the directors or by a qualifying floating charge holder, and the court has supervisory jurisdiction, and creditors can go to court to ask for directions, or indeed the company can, or the administrators, but the court has a very light touch approach, and it's very different to Chapter 11. There are very many fewer applications to court, and the costs therefore as a result are significantly lower. By contrast, the restructuring plan has 2 court applications, but the directors remain in control throughout, and there's no insolvency practitioner formally involved, although very often financial advisors are involved behind the scenes, dealing with the necessary evidence you have to produce to the court to demonstrate that the proposal is fair to the classes of creditors in the circumstances. Sadly, we don't have DIP finance, Howard. That's something that we'd hope might come in with this new procedure, but it hasn't. The company in the restructuring plan can enter into loan agreements looking for new money, but that can only prime or be superior to the existing lending, provided all the existing creditors agree, which they may well not. So that's something that maybe we may have as a feature in the future for this new procedure, but not just at the moment. Finally, one point that I would add about the restructuring plan is that it's available to entities which are not incorporated in England and Wales, provided they have sufficient connection with the UK jurisdiction, and that could be English law agreements or assets in England and Wales, even if they're not actually incorporated here. So it can be used by overseas companies in the same way as a scheme of arrangement has been used by overseas companies for many years. Schemes of arrangement will still continue to be used in the UK. They're very popular. They have been around for over 100 years. And they're often used to do financial restructurings. So in the future, I think we see a mix of schemes of arrangement, restructuring plans, and administration being the choices of rescue procedure in the UK. Thanks, Howard and Guillaume, for summarising the procedures that you have in your jurisdictions. If I just asked you to summarize in a nutshell, what would you say is the key takeaway from this presentation?
Alison, I would say Chapter 11 really provides a troubled multinational debtor with a full range of options and powers to accomplish a restructuring. And there's been a lot of precedent over the years in very significant cases.
Great, thanks. And Guillaume, if you have to summarize in a nutshell, what would your sentence be?
Well, in Canada, we call the CCAA the Businessman or Businesswoman's Act. So I would say it summarizes well what it does. It fixes an insolvency situation in the most beneficial manner for all stakeholders.
Thank you. And for the UK, I would say, well, the new restructuring plan is a groundbreaking change for us, with cross-class cram-down giving us a proper debtor in possession procedure that we've not had before. So interesting times. We hope you've enjoyed this comparison of the different procedures across the 3 jurisdictions. And we very much enjoyed sharing some insights into the rescue procedures in the UK, US and Canada with you today. We hope you have found this presentation interesting, and if you have any queries in relation to the issues we've raised, please contact any member of the Financial Restructuring and Insolvency team at Norton Rose Fulbright, and you'll find details on nortonrosefulbright.com on our website. We look forward to working with you in the future, and would recommend that you consider listening into further videos in our series as and when they're publicised on our website. Thank you very much for your time.
Indeed, from the US as well, signing off. Thanks so much for listening.
And thank you from Canada. Thanks, Alison and Howard. Thanks to all.